Here's a statement that should get your full attention. The beneficiary designations you filled out decades ago on your 401k, your IRA, your life insurance, and your annuity contracts will, with very few exceptions, override anything written in your will. Your will is a beautiful document, carefully drafted, signed before witnesses, perhaps even stored in a lawyer's fireproof safe. But when you pass away, the custodian of your retirement account does not read your will. They read the beneficiary designation on file with them. Whoever is named on that form receives the account. Full stop. No court challenge, no probate battle, no waiting for the executor to get things sorted. Direct payment to the named beneficiary. Now consider this: the Secure Act of 2019 and the Secure Act 2.0 of 2022 fundamentally changed how inherited retirement accounts are taxed and distributed. Many retirees filled out beneficiary forms in the 1990s or 2000s under rules that no longer apply, and they have not updated the form since. The consequences of an outdated beneficiary designation under the new rules can range from a minor tax inefficiency to a catastrophic outcome where the wrong person inherits, or where the right person inherits but pays hundreds of thousands of dollars more in tax than necessary. If you are retired or approaching retirement, the single most important afternoon you will spend this year may be the one you devote to reviewing every beneficiary designation on every account you own. This video is for educational purposes only and is not personalized tax, financial, or legal advice. Consult a qualified professional for guidance on your specific situation. Estate planning is state-specific, and the interaction between federal retirement account rules, state inheritance law, trust law, and tax law is deeply complex. The information here is designed to help you identify the right questions to ask the attorney and tax professional who know your full situation. Let me start by explaining what changed under Secure Act 2.0. The big change for most non-spouse beneficiaries was the elimination of the stretch IRA, replaced with a 10-year rule for most beneficiaries who inherit after December 31st of 2019. The rule requires that the inherited account be fully emptied within 10 years of the original owner's death. For a traditional IRA, this means the beneficiary pays ordinary income tax on everything that comes out, compressed into a 10-year window that often coincides with the beneficiary's peak earning years. For a Roth IRA, the 10-year rule still applies to the timing of distributions, but the distributions are tax-free if the account has met the 5-year holding period. A few categories of beneficiaries, called eligible designated beneficiaries, can still use the old stretch rules. These include a surviving spouse, a minor child of the decedent until they reach the age of majority, a disabled or chronically ill beneficiary, and a beneficiary not more than 10 years younger than the decedent. Everyone else, including adult children, grandchildren, and most other beneficiaries, is subject to the 10-year rule. Consider Nancy. She filled out her beneficiary form on her traditional IRA in 1998, naming her 3 adult children equally. That designation is still on file with her IRA custodian. Nancy is now 74, and her IRA has grown to $900,000. If she passes away today, each of her 3 children will inherit $300,000 and will have 10 years to empty the inherited account. Each child, depending on their current income and tax bracket, could pay between 20 and 30% in combined federal and state tax on those distributions. That is potentially $180,000 across the 3 children in accelerated tax versus what they would have paid under the old stretch rules, where each could have taken small distributions over their full lifetimes at much lower marginal rates. Nancy's beneficiary designation was filled out under the old rules. It still names the right people, but the tax context has changed dramatically, and some of her children might benefit from a different structure. What could Nancy do? First, she could consider Roth conversions during her lifetime. If she converts portions of her traditional IRA to Roth over the next several years, her children would inherit a Roth account, which is still subject to the 10-year rule but produces tax-free distributions rather than taxable ones. The conversion triggers tax during Nancy's lifetime at her bracket, which is often lower than her children's bracket. Second, she could consider qualified charitable distributions to reduce the IRA balance that eventually passes to her children, directing some of her assets to charity during her lifetime. Third, she could update her beneficiary designation to include specific allocations or contingent beneficiaries based on her current family situation, which may have changed since 1998. Here's another scenario. Walter named his wife Ruth as his primary beneficiary on his 401k in 1985. They divorced in 2003. Walter remarried in 2005 to a woman named Joyce. Walter assumed that his divorce decree, which included property division, automatically removed Ruth as his beneficiary. In many states, and under many retirement plans, that assumption is wrong. The federal law governing 401k plans, ERISA, generally treats the named beneficiary as the binding designation unless specifically updated. When Walter passes away in 2025, his 401k of $650,000 may go to Ruth, his ex-wife from 1985, rather than Joyce, his current wife of 20 years. Joyce may have legal recourse, but the process will involve lawyers, court time, and possibly an outcome that does not match what Walter intended. A 10-minute update to the beneficiary form in 2003 would have prevented the entire situation. The lesson is that life events, divorce, remarriage, births, deaths in the family, estrangements, and reconciliations all need to trigger a review of your beneficiary designations. An outdated designation is like a voicemail left by your past self. It keeps playing long after the message stopped being current. Here is another trap that Secure Act 2.0 highlights: naming a trust as a beneficiary of an IRA without understanding the pass-through rules. A properly drafted see-through trust can preserve some of the beneficiary tax. Treatment, allowing the trust's beneficiaries to be treated as if they inherited directly. But a poorly drafted trust, or a standard revocable living trust that was not specifically designed to hold retirement assets, can cause the entire IRA to be treated as distributed immediately upon the owner's death, accelerating all the tax into the year of death. The distinction between a conduit trust, an accumulation trust, and a see-through trust matters enormously. If you have named a trust as the beneficiary of any retirement account, have an estate attorney review the trust language specifically in light of Secure Act 2.0. The rules are different from what they were before 2020. Let me also address per stirpes versus per capita designations, which many retirees misunderstand. Per stirpes means that if a primary beneficiary predeceases the account owner, that beneficiary's share passes to their descendants. Per capita means the share is redistributed among the surviving primary beneficiaries. If you have 3 children and you name them all with a per stirpes designation, and one child passes away before you, that child's share goes to that child's children, your grandchildren. Under a per capita designation, the deceased child's share would be redistributed among your 2 surviving children. Most parents want per stirpes, but many beneficiary forms default to per capita, unless you specifically elect otherwise. Check your current designations carefully. Another trap is minor beneficiaries. If you name a grandchild as a beneficiary and the grandchild is a minor when you pass away, the funds cannot be distributed directly to the minor. A court-appointed conservator or custodian under the Uniform Transfers to Minors Act must handle the funds until the minor reaches the age of majority, which varies by state. Many grandparents who name grandchildren do not realize this and assume the parent of the grandchild can simply manage the money. The court process adds delay and expense and may not align with your intent. Consider naming a trust for minor beneficiaries rather than naming them directly. Yet another trap is charitable beneficiaries combined with individual beneficiaries on the same account. If you name multiple beneficiaries on a single IRA, some of whom are individuals and some of whom are charities, the IRS rules require separation of the beneficiaries into separate accounts by September 30th of the year following the year of death to preserve the individual beneficiary's ability to use their own life expectancy, or the 10-year rule. If separation does not occur, the entire group of beneficiaries may be subject to the most restrictive rule, often a 5-year rule, because the charity is considered a non-designated beneficiary. A cleaner approach is to split the IRA into separate accounts during your lifetime, one for individual beneficiaries and one for charitable beneficiaries, or to use qualified charitable distributions during your lifetime to fund your charitable intent, leaving the IRA itself to go entirely to individuals. Consider Arthur and Beatrice, retired from a Pittsburgh suburb. Arthur was a metallurgical engineer and Beatrice ran a small catering business. They have 2 children and want to leave 10% of their combined retirement accounts to their church. Originally, they named their 2 children and the church as equal co-beneficiaries on each IRA. Their estate attorney pointed out the trap, and they restructured. They set up 2 IRAs, one to be split equally between the 2 children, and the other to be left entirely to the church. The children now benefit from the 10-year rule on a cleaner account structure, and the church receives its gift directly without affecting the children's tax treatment. The attorney fee was about $2,000. The tax savings across the family are likely to exceed $20,000. Beyond the main retirement accounts, there are other designation forms that need review. Life insurance beneficiaries, annuity beneficiaries, payable on death designations on bank accounts, transfer on death designations on brokerage accounts, transfer on death deeds on real estate, where state law allows. Each of these operates similarly to retirement account beneficiary designations, passing the asset outside of probate directly to the named beneficiary. Each can be outdated. Each deserves review. Here is a checklist for a comprehensive beneficiary review. First, gather every account you own that has a beneficiary designation. This includes 401ks, IRAs, Roth IRAs, Roth 401ks, 403bs, 457 plans, pension plans, life insurance policies, annuities, bank accounts with payable on death designations, brokerage accounts. with transfer on death designations, real estate with transfer on death deeds if your state allows, health savings accounts, and any other financial account that has a named beneficiary. Second, contact each institution and request a current copy of the beneficiary designation on file. Do not rely on what you think you filled out. Get the actual current document. Third, review each designation against your current intent. Is the right primary beneficiary named? Is the right contingent beneficiary named? Are allocations what you want? Is per stirps or per capita specified correctly? Fourth, coordinate across accounts. If one child has been treated differently across different accounts, is that intentional? If multiple accounts have the same beneficiary, is that consistent with your overall plan? Fifth, coordinate with your will and trust documents. The beneficiary designations should complement, not conflict with, your estate plan. An attorney can help identify conflicts that could create legal challenges at death. Sixth, update any designations that are out of date. Use the current forms provided by each institution. Keep copies of the new designations in your records. Seventh, communicate with your beneficiaries to the extent appropriate. Your beneficiaries should know where the accounts are held and who to contact at each institution. They do not need to know exact amounts, but they do need to know where to look. Eighth, review again every 3 to 5 years, or sooner if any major life event occurs. Let me address one more specific issue. The Secure Act 2.0 expanded Roth options in 401k plans, allowing employer matching contributions to be directed to Roth accounts. Many workers are now accumulating Roth 401k balances that they will eventually inherit or pass on. Beneficiary treatment of Roth 401ks has specific rules that differ slightly from traditional 401ks and from Roth IRAs. When you pass on a Roth 401k, the beneficiary must either take distributions under the 10-year rule or roll the account into a Roth IRA before taking distributions. A surviving spouse has additional options. If you have substantial Roth 401k balances, understanding these rules and possibly rolling to a Roth IRA during your lifetime can simplify the situation for your beneficiaries. Another Secure Act 2.0 change worth mentioning is the expansion of catch-up contributions for workers aged 60 through 63 with special higher limits taking effect in 2025. For retirees still working part-time or for retirees whose spouses are still working, these expanded catch-up provisions can accelerate retirement account accumulation in the years just before full retirement. That accumulation will eventually pass through the beneficiary designation system, so keeping designations current for these accounts is important. Let me tell you about Helen and Richard. They were both retired and had been married for 46 years. Helen passed away in 2023. Richard received all of her IRAs and other retirement accounts through properly named beneficiary designations. He was able to roll her accounts into his own IRAs under the spousal rollover option, which allowed him to continue deferring RMDs until his own required beginning date. He also updated his own beneficiary designations after Helen's death, removing her as his primary beneficiary and naming their 3 adult children equally as primary beneficiaries and their grandchildren as contingent beneficiaries per stirpes. He coordinated with his estate attorney to make sure the updates aligned with his revised will and trust. The entire process took about 3 hours, spread across 2 meetings with the attorney and 1 afternoon calling his account custodians. It cost a few $100s in legal fees and nothing in custodian fees. When Richard eventually passes away, his beneficiaries will inherit smoothly without court battles, without outdated forms creating confusion, and without the tax inefficiencies that come from uncoordinated designations. If you have not done this review in the last few years, it is time. The Secure Act 2.0 changes are fully in effect in 2026, and the inheritance landscape for retirement accounts is structurally different from what it was before 2020. The people named on forms you filled out in the 1990s or 2000s may still be the right people, but the legal and tax context has shifted substantially, even if you make no changes. Confirming that the current forms reflect current intent is worth the time. Specific forms to be aware of include Form 8822 for updating your address with the IRS, which ensures that any correspondence about your beneficiaries or estate reaches you. If you have multiple IRAs or 401ks at different custodians, each has its own beneficiary form. Each is a separate document that must be reviewed and updated independently. Your bank, your brokerage, your insurance company, and your retirement plan administrator each maintain their own records. Do not assume that updating one updates the others. One final consideration. Some retirees are reluctant to do beneficiary reviews because the subject feels morbid or because they have not thought through what they want. That reluctance is natural and common. But the cost of not reviewing is often borne by the people you love most, who may face unnecessary tax bills, legal battles, or delays in inheriting assets that were meant for them. A well-organized beneficiary structure is one of the most valuable gifts you can leave behind. It is also one of the easiest to create. The documents are usually free, the updates are straightforward, and the consequences of getting it right are felt for years by the people who inherit. Let me close with a specific walkthrough of what a quarterly beneficiary review looks like in practice. On the first weekend of each quarter, set aside 2 hours to pull up every financial account you own. Log into each one or call customer service. Ask for the current beneficiary designation. Compare it to what you expect. Note any discrepancies. If everything is current, mark the date and move on. If anything is out of date, request updated forms immediately. Keep a single paper folder, physical or digital, with a dated printout of each current designation. That folder becomes your family's roadmap in the event something happens to you, and it becomes your audit trail for the next review. Retirees who build this habit find that the annual full review takes 30 minutes instead of a full afternoon, because most of the accounts have been confirmed recently. And the peace of mind that comes from knowing every designation is current, every beneficiary is correct, and every form is on file is genuinely valuable. Estate disputes among heirs are one of the most common sources of family conflict after a parent's death. A well-maintained beneficiary structure is one of the strongest defenses against that conflict because it leaves no ambiguity about who inherits what. If you found this video useful, I would encourage you to subscribe to the channel for more in-depth discussions of retirement, finance, and estate planning. I cover specific topics that many mainstream financial shows overlook, with a focus on the practical forms, deadlines, and decisions that affect real retirees. If you have a specific question about beneficiary designations that you think other viewers might benefit from, drop it in the comments. I cannot give personalized advice, but your question may help shape a future video that helps many viewers at once. Until then, take care of your beneficiary designations, coordinate with your estate plan, and protect the people you love with clear, current, and properly structured documentation. An afternoon of paperwork now saves months of heartache and thousands of dollars later. That is a trade worth making.